SJC-13624, Theisz versus Massachusetts Bay Transportation Authority.
Okay, Attorney Sage, whenever you're ready.
Madam Chief Justice, may it please the court, Jennifer Lee Sage on behalf of the Massachusetts Bay Transportation Authority, and with me is Attorney John Bonastelli. This case is here before you on a further appellate review of the appeals court decision upholding the denial of summary judgment to the MBTA on its claims for immunity from suit under the Tort Claims Act. This case arises out of an accident that occurred on March 3rd, 2015, when the plaintiff was physically assaulted by an MBTA bus operator. The plaintiff claims in this action that the injury occurred because the MBTA negligently trained, supervised, and/or retained this bus operator. Under the case law of this court and the appeals court, those claims are barred by the Section 10J of the Mass Torts Claims Act. Under Section 10J, the MBTA is immune from liability unless the condition or situation was originally caused by the MBTA. Under Brum v. Dartmouth and its progeny, whether a public employer originally caused a condition or situation requires a two-pronged analysis. The first prong is that it requires an affirmative act and not a failure to act to create the condition or situation that the claims resulted in the harm. Moreover, that affirmative act must have materially contributed to creating the condition or the situation that resulted in the harm. The crux of the plaintiff's claims in this case is that had the MBTA acted differently by way of better trained or better supervised, or simply fired the bus operator after certain reported bad behavior, this accident might have been averted. But by those very statements, it explains why.
The appeals court decisions, it's very carefully sort of set out, and it rises or falls on the idea that we've never had the third party is an employee. It's not, it's not nature or a kid or a bully, but an employee. And there's some logic to that, right? That, you've hired this person, you've maintained this person, you've kept them there despite some odd and even reckless acts by this person. So why isn't the appeals court right? I mean, it seems there's no case like this, is there, that goes the other way?
The third party issue, Your Honor, is that issue has actually already been decided by this court and the appeals court. In Brum, the court ruled that the exemption provides immunity with respect to all circumstances, including the violent, tortious conduct of a third party.
Yeah, but was the third party an employee? That's the... In Brum, it was. I can't remember the facts in Brum. Is the third party an employee in Brum?
In Brum, the original cause analysis is a claim-based analysis, and thus all cases that trigger this 10J exemption, the plaintiff's claims have been that the public employer or employee was the original cause of the harm. And Brum is a case of a fatal stabbing of a student at a school. And in that case, the plaintiff...
It was a student that stabbed, right? It wasn't the employee who stabbed. It was the student who stabbed, right?
It was the student that was stabbed. You're right, Your Honor.
So doesn't that take us into a different kind of analysis? I mean, I understand some of these cases about original cause, start to sound like failure to prevent, but in the employment context, the person wouldn't be there but for you and putting them there and keeping them there and training them the way they're trained, right?
In this case, it's significantly different because this is a case in which the employee, the bus operator, committed an intentional tort. And to hold that the original cause of the plaintiff harm was for the MBTA to be held vicariously liable for the intentional tort of the bus operator would fly in the face of Chapter 10C, which the legislature has expressly prohibited public employers from liability.
But vicarious liability is different from negligent supervision or negligent hiring. Vicarious liability is, he did it, you're responsible because he's your employee. They're building a separate cause of action based on your own negligence. There is a difference between 10C and 10J, right?
There is a difference between 10C and 10J. This is a claim where the plaintiff's claim is not based upon a vicarious liability claim. That claim has been dismissed at the outset on a motion for judgment of pleadings in this case. The plaintiff in this action is claiming that the MBTA negligently trained.
Isn't it the promotion that was the big part? As I saw it, it was the fact that he was a part-time employee and then he was promoted despite all these missteps and warning signs to that of an unsupervised full-time bus driver, right?
Yep.
And that put him in a position to do what he did to the plaintiff. The affirmative act is the promotion, and then that materially contributed to the harm in that he's in this position to interact with the public.
The change of work status from part-time to full-time, I would argue, is a failure to prevent harm. The alternative being the MBTA should have, maybe could have and should have fired him at that point, but didn't and failed to do so. That is a failure to act that's precluded by this exemption. Even if we were to assume that, or to the extent that the court considers full-time status as an affirmative act, that would still fail under the 10J original cause analysis because it doesn't meet the materially contributed to creating the specific harm that resulted in the plaintiff's harm. There was no...
Can you just remind me, did
Sure.
the employee here have a history of violent conduct?
In the timing of
Yeah, so that's just a yes or no.
he had one instance, in the record is somewhat factually ambiguous as the facts underlying that incident, but there is potentially an incident, it's the Bergeron incident that occurred in October 2013, where there was some violent behavior by the bus operator.
And when was he promoted?
He was promoted prior to that,
Okay, and then they
Right.
retained him
and he
in
was,
that position?
he was continuously employed as a bus operator
Okay.
subsequent to that.
Is your rule of law categorical? Is there any scenario by which you promote someone who's unqualified and dangerous and put them in a position to harm people, where there be no liability? I'm thinking of a police officer, right, that's not properly screened, and they put them out on the beat, and they know the person has a very violent temper and they shouldn't be there. So what do you say to that?
There is a case in which, it's a Massachusetts District Court case, in which promotion was found to be a original cause of the harm, and that's Pettingill v. Curtis. And in that case, a librarian who was known to be sexually abusing Boy Scout members in the library was then promoted to be the director of the library, giving him unsupervised and more access to this particular plaintiff who ended up being sexually abused. And
I guess that's a better hypothetical than I could come up with, but yeah.
in this case, is far removed from that case.
But you will agree that that was properly decided, that the library would be on the hook?
I think that was properly decided.
Okay.
Why? Why is that properly decided and this one isn't if there's a prior incident of violence with this person?
Because there's no affirmative act here in light of this prior knowledge. Retention is not an affirmative act. It is a failure to
Sorry, I missed what the word you just said.
retention.
But
Retain-
try promotion, though.
No, he was not promoted, and that's the importance of the timing. Prior to his promotion, there's no evidence in the record that the MBTA was aware of his violent propensities. There's in the 24 months that he worked as a part-time operator, in the record, there's 4 instances of reported alleged bad behavior. One is failing to stop at a stop sign, leaving a bus stop early, passing by a station of people who were waiting for the bus, or failure to give his badge number to a offending motorist that did a U-turn in front of his bus. So prior to the promotion,
About the police incident?
the police incident happened after the promotion. So prior to the promotion, there's no notice to the MBTA that this operator had any violent propensities. In furtherance to that, there was no affirmative act taken by the MBTA to have materially created the assault on the plaintiff. In Cormier versus City of Lynn, that was a case in which a particular student was being bullied at a school.
So getting back to what you said, so the incident that we're most concerned about is this March 23, 2013 incident with the driver?
No, Your Honor. March 2013 is...
I'm sorry, that was when he's promoted.
That's correct.
All right.
And then
And then after that was a physical altercation with the customer?
That's correct,
Okay,
Your Honor.
all right, thank you.
And so, even in the original cause analysis, prior knowledge of bad acts is not the linchpin in the original cause analysis. And I would direct the court attention to the Cormier v. Lynn case.
But again, that's a case where the third party is
Yes,
there
Your
are two
Honor.
students involved and not an employee.
Yes, but even in that case, the claim was against the public employee of the principal in the school and the town for failing to prevent that assault. And in that case, a student the school was put on notice that these assailants were going to come back to the school and attack this particular student. And in fact, the three assailants did come back to the school visibly armed and led to the stabbing of the student. I'm sorry, that's the Brum case. The Cormier case is very similar in the facts and relied heavily upon Brum. In Cormier, it was a bullying case in which a student was being bullied, and the school was put on notice that the student was being bullied by the bully that ended up pushing him down the stairs. And the school was asked by the parents of the victim to prevent this bullying. However, the school took no preventative action, and ultimately the student was pushed down the stairs by the bully. And the court held that placing the bully and the victim in the same class is too remote as a matter of law, and failure to act in a manner to ensure safety is precluded under the act.
You're not arguing, unless I'm wrong, that 10J precludes the tort of negligent supervision?
10J precludes negligent supervision.
No matter what?
I would be hard-pressed to find a scenario in which negligent supervision would not be precluded.
Except if the employee had some sort of bad behavior, physical harm to somebody, and then was promoted.
The librarian case?
That wouldn't be a supervision case, that would be a...
Negligent promotion, I guess that would be.
That
right?
would be an affirmative act,
But
whereas...
why is retention different from promotion? I mean, this person would never be driving that bus unless he was hired by the MBTA, trained by the MBTA, retained by the MTA, and promoted by the MTA. Doesn't that, and I'm trying to understand why the librarian is different. The librarian who's the pedophile is different. Why?
Because there was an affirmative act of changing his job duties, increasing the risk to the plaintiff, this particular
But we have the
victim plaintiff.
same escalation of he gets hired, he gets trained, he gets retained, he gets promoted. If without the MBTA, he's not there. I'm not disagreeing with you so much as I don't understand the distinction and why, back to Justice Gaziano's question, you're not creating a categorical rule on this, but go ahead.
And I would again direct the court's attention to the Brum case, J&J v. Commonwealth, where, you know...
All of those are forces outside of, they're all something that's not an employee, or it's a student, it's a playground, it's just different, all those cases. That's what I thought I originally understood your argument when I read your brief, but then I read the appeals court decision, and there's a logic to this that I can't get around unless you help me get around it.
Well, I think the appeals court has already expressly decided that issue in Jacome, which is the lifeguard case.
I thought it was the waves, right, that killed the
Yes,
kid.
but in that case, the plaintiff specifically argued in that case that this 10J immunity was a limited grant of authority, limited to the violent tortious of a third party, and not a public employee, as the plaintiffs were claiming in that case. And the plaintiff was claiming in that case it was the public employee's failure to lifeguard, which they argued was
The appeals court decision, I thought your argument was basically read out the originally caused by the public employee. There's a limited portion that they kind of skipped, correct?
I'm sorry?
The appeals court focuses on the language of a third person,
Yes.
but that's illustrative because it illustrates originally caused by a public employer, correct?
Yes. And then, in the Jacome, in that case, the court rejected that specific argument and held that the 10J immunity was not restricted to claims arising from tortious behavior of third parties. That holding was then affirmed in Moore v. Bill Ricca in 2013, and then again in Clevin versus Newton in 2020. In Clevin, the court ruled that although Section 10J is often applied to situations where harmful consequences resulted from the tortious conduct of a third party that is a non-government employee, it is clear from the 10J language that the immunity is not limited to situations involving the third-party tortious conduct. In a case that was decided by this court more recently is the Doe versus Mass Trial Courts. In that case, it was a court officer who was sexually abusing inmates that were being transported in the courts. And although this court didn't address the 10J, the Superior Court down below in that case held that even though it was a public employee who was committing the sexual assault, that 10J and 10B both barred the plaintiff's claims in that action as a failure to prevent harm.
Okay, thank you. Oh,
Oh,
yeah, time's up.
my time is running out. I thank you for your time, and the MBTA requests that the decision of the Superior Court be reversed and summary judgment entered for the MBTA.
Thank you.
Thank you.
Okay, Attorney Rich.
Thank you. May it please the court, and good afternoon. Make no mistake, the MBTA, the relief the MBTA seeks in this case, and they say it right at page 9 of their reply brief, is 10J bars the plaintiff's claims even if the MBTA knew or should have known of Smith's violent propensity and that he would some point in the future endanger the public.
Okay, but let's assume that there is this temporal bar, right? So what do you say to that? What do you say to they promoted and then the bad behavior?
Yeah, so I think my first answer to that, and I'll come back because I want to answer your question directly, is that 10J simply doesn't apply here, as the appeals court found, because to do so, the court would be required to read out the last phrase, which exempts from the exemption, or not originally caused by the public employer or any other person acting on behalf of the public employer. I'm going to come back to that, but I want to answer your question, which is really sort of, what are the affirmative acts? And I think that from my perspective, they fall into 3 buckets. The first is the promotion, which we've pointed to. And the Bonnie W. case, that's the case where the probation officer recommended someone to go work in a trailer park and there was an injury and the court found that claim was not barred. So that's simple. There's a temporal aspect.
Private sector case, right?
No, that was Bonnie W. versus Commonwealth.
10J case?
It was, yes, I think so. It's an assault in a trailer park. The probation officer had recommended the individual for a promotion, and he
But as I line up these so-called bad acts, or some of them are fairly innocuous. The only one that bothers me is as the chief points out, the post-promotion.
Yeah, so
incidents
let
of
me
violence.
talk about that. So the first is the Bergeron, which is the one where he gets up out of the bus and he beats someone up and the bus crashes into that. The MBTA actually took an affirmative act in connection with that, and they suspended him for 1 day. And I would argue that the act of suspending him for 1 day is an affirmative act. It was an inadequate affirmative act, and it is one that materially contributed to what inevitably, what did happen and what was clear would have happened after that.
So it was a retention that you have a problem.
Yeah, but it was retention. Part and parcel of this was the affirmative decision to suspend him for 1 day. That was a conscious, intentional, affirmative act. I would also say
That just doesn't seem even remotely plausible, that the MBTA stepped up and disciplined for 1 day, 1 week, 1 year, a month, I don't care. They actually took an action, and you're saying that therefore they're on the hook for being liable because they took a punitive action against the employee?
Well, if you, and your point is a good one, which is it gets into this whole conundrum where why this makes no sense in this context.
Yeah, I think
because-
that's where you're better off, on the affirmative act, retention not being an affirmative act. Maybe that would be a better place to put your energy.
But the point is to your point, Your Honor, I think it's well said, is that if you would accept the idea that retention can't be an affirmative act or liability, it encourages an employer, a public employer, to do nothing. Because the more they do, the more affirmative that they are acting, and it turns this
So instead of arguing that, can you tell me why retention should be included as a basis for liability?
Well, because the entire process by which one is retained is a holistic act of analysis of one's performance. And let me just give you a specific example.
I understand the concept of retention.
I appreciate that. But let me try and give you a real-world example. So we talked a little bit about the last act, which happened in February of 2014, where he gets into a verbal altercation with a police officer and ultimately leads to him being arrested. No discipline associated with that. 3 months later, he is written up for excessive absenteeism from work. So I would respectfully suggest that you have to look at this entire pattern of conduct holistically and as part of an overall disciplinary regime, all of which are not passive activities, but part of an affirmative program in a manner of acting in an affirmative way with regard to your employees who are ultimately out there interacting with the public, and to suggest that the appropriate.
Well, the question isn't whether he's a bad employee. The question is whether he's a dangerous employee. And I don't know how excessive absenteeism says he's a dangerous employee.
And I'm not suggesting someone who's absent from work is dangerous. I'm suggesting that the mere act of supervising, retaining, to Justice Wendland's question, is an affirmative activity in a holistic sense. And you can't pull out one and say, well, you didn't discipline him, so that's not an affirmative act. You didn't do anything, and so we're off the hook. It encourages a lack of discipline. It encourages a lack of supervision. And that can't be what 258 is intended to do. You know, it's not all that different. It's a little bit different, but the analogy is there. The Devlin case from the appeals court, and that's where the Commonwealth allowed convicted inmates to work in an area where civilly committed inmates worked. And it was considered to be an original cause and an affirmative act, and 10J was found not to apply.
What's the case? I think it's an appeals court case that says that when we look at originally caused, it has to exact in scrutiny. There's some heightened language other courts are supposed to apply.
I'm not sure the case to which you are referring, Your Honor, but I would refer you to the Kent case, which is an SJC case. where it says, it talks about an original cause. It says it's not an affirmative act by a public employer, but it's one that, quote, creates the conditions or situation that results in the harm inflicted by a third party. By a third party. That's what this court held in the Kent case. It's also what the court, the appeals court in the Sorrell case held, where we say, and that's the case where there was a failure to subdue an inmate, and there was a tussle, and then the correctional officer injured the plaintiff in that case. And the appeals court said, we observe in this regard that the cases to date construing 10J and holding it a bar to tort liability involve fact patterns where a third party, not a government actor, directly harmed the plaintiff. And that's where I start, really, and sort of jumped over, which is 10J doesn't apply to this particular fact pattern. And the reason, and all of you have commented in...
I don't know if that makes sense. So, meaning you're proposing the exact opposite categorical rule that all employees are, all acts by employees they're responsible for?
No, of course not. Because what I am saying is that 10J doesn't exempt a claim for negligent hiring, training, and supervision where the perpetrator, the ultimate perpetrator of the harm is an employee of the public employer. And ultimately, whether that claim fails
Wait, how else would you have negligent supervision if they weren't an employee?
Well, but fair enough. But my point is, if you read every single case, and all of you asked this in one way or the other, all the cases that hold that 10J applies fall into one of three buckets. One is the genuine third party, the bully, the inmate who kills the correctional officer, et cetera. Two is this natural cause. I think it's the Jacome case where that comes in. And three is when the plaintiff does something to them, or the plaintiff's kin does something to themselves. They hurt themselves and the claim. There is not a case that has been decided by this court or the appeals court, quite frankly, the district court, that's at least cited by the parties, where the injury was directly caused by the public employee while working in the course and scope of the public employee's work. And that's exactly why...
Well, the scope of his work was to drive the bus, not to beat up passengers, right?
But I'm distinguishing from someone's at home and does something terrible, and I think there's an unreported district court or appeals where a police officer off the clock beats up a partner. And there was a lawsuit that was brought that said, hey, you knew this person was a bad guy and you continued to employ him. And I think there was a presentment problem in that case. But in any event, so I'm saying where someone's at work doing their job and they hurt someone in an intentional way, there isn't a single case that has...
But that can't be right, though. So this person, you've got a driver who's never done anything wrong, and he rapes somebody because she's the last person on the bus. They don't know he's a rapist. They have no knowledge of that. They can't be the original cause of that.
So, but
that's different from this.
But that case would be not... 10J would not be a defense to that case, but the case would be disposed at summary judgment because there would be no evidence to support a claim of negligent supervision, negligent hiring, or negligent...
We have to figure out, what's the cart and what's the horse each time. And that's not easy because the cases, let's face it, are not that clear. But I don't know where you're going with the last part of this thing.
Well, where I'm going is that 10J, the language in 10J is clear that says that it cannot be invoked. That part doesn't say, but unless where it is not originally caused by the public employer or any other person acting on behalf of the public employer. And any other person acting on behalf of the public employer, that language has to have meaning in 10J. Or it wouldn't be there.
But caused by the employer, your best argument, which is articulated by the appeals court, is this whole employment setup with this, You hired, I mean, they hired, retained, promoted, and kept a person they knew was sort of an accident waiting to happen, volatile and dangerous. And that's the cause of this, not that he's volatile and dangerous and they don't know anything about it.
I don't disagree with you, Your Honor, but the appeals court at 825 of the decision says the reference to, quote, the violent and tortious conduct of third persons in Section 10J does not include the conduct of public employees. That was their finding, that 10J didn't apply. They then go on to go through the analysis of saying, but even if it did, based on this particular fact pattern, there is sufficient evidence in the record which would warrant a jury trial on whether the conduct of the MBTA in permitting this behavior, permitting this person, retaining this person, is a sufficient original cause such that the case it presents triable issues. And, but again, it's not just me saying it. This court in Kent specifically said, and I already said this, but an affirmative act by the public employer that creates the condition in harm inflicted by a third party. That's, again, a reference to the perpetrator is someone other than them.
So you're saying 10J doesn't apply, and so there is no bar to the plaintiffs?
Yes, that the summary judgment was properly denied, and they go forward to trial. That's all we're looking for today is trial. And, after, I think, 8 years, this case has been pending. And so, but my second argument is, even if the court does find there is framing for a 10J argument here, the conduct at issue here, the conduct by the MBTA, is under applicable law, particularly as framed by the Kent case, not the Kent ruling, but the ultimate decision in Kent, but as framed by where the act must materially contribute to the specific condition or situation that resulted in the harm. Their conduct in allowing this person time after time after time presents a triable issue as to whether they were negligent in their supervision, retention, and training, et cetera. So that's and based on the Kent decision and its progeny and how it defines an original affirmative act. The very last thing I would say in my last 30 seconds is that I would urge the court to not do what they ask, which is to overturn Dobos and Dover's Blanchard. It's been the law of the land for 35 years in recognizing negligent supervision type cases. There's no basis to do that. I'm not sure it's even properly before the court, but even if it is, I would urge the court not to. The amicus brief does a wonderful job of articulating why, and I would refer the court to that.
Okay.
Thank you very much.